After the complaint has been filed and served, the next step in the litigation process is up to the defendants. Today's lesson will focus on responding to the complaint. We will discuss the different types of answers, drafting an answer, and what happens when a defendant fails to answer a complaint. We will also go over project number 2, which involves drafting an answer. After a complaint is filed, a defendant has many options. They may either contest the action by filing a motion or an answer, negotiate a settlement, or do nothing. Today's lesson will focus primarily on answering the complaint. If the defendant chooses to answer the complaint, there is a certain format that should be followed. The answer should contain a general denial in which the defendant denies all allegations in the complaint. The defendant should also do specific denials in which the defendant either admits or denies all or parts of each allegation contained in the complaint. Here is an example of language used in a general denial and specific denial. In a general denial, the defendant simply states that defendant denies each and every allegation contained in the complaint. The specific denial admits or denies the individual paragraphs contained in the complaint. For example, defendant denies the allegations contained in paragraph 21, or defendant admits the allegations contained in paragraph 21. The defendant may also admit a part of the allegation and deny a part of it. For example, defendant admits that it is a resident of the state of Hawaii, but denies all of the other allegations contained in paragraph 21. Answers should also include affirmative defenses. An affirmative defense are facts or circumstances that defeats the plaintiff's claim, even if the plaintiff can prove every contention alleged in the complaint. For example, the statute of limitations is an affirmative defense in all cases. Fraud is an affirmative defense to a breach of contract claim. What is an affirmative defense to a negligence cause of action? Contributory negligence or assumption of the risk are both affirmative defenses. Rule 8 of the Hawaii Rules of Civil Procedure address the requirements for an answer. The rule states that a party shall state, in short and plain terms, defenses to each claim asserted and shall admit or deny the averments upon which the adverse party relies. This is what we just covered with the general and specific denials. You will note that the rule also says that if a party is without knowledge or information sufficient to form a belief as to the truth of the averment, the party shall so state, and this has the effect of a denial. Rule 8, subsection C, references the affirmative defenses that can be asserted in the answer. Similar to the complaint, an answer must also include the same caption as set forth in the complaint and must use separate paragraphs for each statement alleged in the answer. When drafting the answer, the caption should be identical to the caption in the complaint. The body of the answer should also include the general and specific denials, the affirmative defenses, prayer, and signature. After the answer is prepared, it must be served on the plaintiff or the plaintiff's attorney, and it must be filed in court. The procedures followed for accompanying service and filing depend on whether the answer is subject to electronic filing. If an answer will not be electronically filed, a copy of the answer is served on plaintiff's attorney, and a copy of the answer is served on the attorney for any other co-defendant who has previously responded to the complaint. An answer can be served personally or by mail. A certificate of service showing who was served, how the answer was served, and by whom it was served must be prepared. Most courts have liberal rules regarding the amendment of any pleading, including an answer. Under the federal rules and Hawaii state rules, as long as a case has not been placed on the trial calendar, a party can amend an answer any time within 20 days after it is served. If more than 20 days has elapsed, or if the case has been placed on the trial calendar, the answer can be amended only by written consent of the adverse party or with permission of the court. A defendant's failure to answer the complaint may result in a judgment by default against the defendant. The court clerk or the court may enter default or default judgment against the defendant. The responsibility then is placed on the defendant to seek to set aside the default or default judgment. Rule 55 of the Hawaii Rules of Civil Procedure addresses what happens when a party fails to respond to a claim filed against them. Default and default judgment may be entered by the court clerk or by the court. Rule 55 also addresses the circumstances under which a defendant may seek to set aside the default or default judgment. Project number 2 involves drafting an answer to the complaint that you drafted in project number 1. Review the causes of actions alleged in the Sutanovich v. Duvey complaint together with the affirmative defenses alleged in the answer filed in that case. Your assignment is to review the complaint you drafted in project number 1 and draft an answer in response to that complaint. The project number 2 memo and supplemental materials can be found in the Resources folder, project number 2 subfolder. Thank you for watching today's video. Please proceed with completing this week's activities.